Transfer of parental rights at age of majority, IEP. In Maryland, parental rights do not transfer to children with disabilities on reaching the age of majority, except under limited circumstances. Under Maryland law, in certain limited circumstances, all rights accorded to the parents under IDEA shall transfer to a child with a disability. This transfer occurs when the child reaches the age of 18 years, if the child has not been adjudged incompetent under state law and there is documentation that the parents are unavailable or unknown, and the child requests that the parental rights be transferred to the child rather than have a parent surrogate appointed. The parents have not participated in the special education decision-making process for the child after repeated attempts by the public agency to involve the parents over the previous year. The parents have affirmatively rejected participation in the special education decision-making process. The parents cannot participate in the special education decision-making process due to prolonged hospitalization, institutionalization, or serious illness or infirmity of one or both of the parents, and the parents have consented to the transfer of rights to the child. The parents cannot participate in the special education decision-making process due to extraordinary circumstances beyond their control, and the parents have consented to the transfer of rights to the child. Or the child is living outside of the parent's home and is not in the care or custody of another public agency. If the parents of a child with a disability, with whom the child resides, do not consent to the transfer of rights to the child at the age of 18, and the child has not been adjudged incompetent under state law, either party may file a due process complaint to determine whether the rights should be transferred. If a child with a disability has been represented by a parent surrogate in accordance with federal and state laws and regulations, the public agency shall provide any written notice required under federal and state laws and regulations to both the child and parent surrogate. All other rights afforded the parent surrogate under IDEA shall transfer to the child if the child has not been adjudged incompetent under state law and the child requests that the rights transfer. Mediation. Mediation is a voluntary process for all parties that may be used at any time by the parents of a child with a disability and the public agency responsible for the education of the child to resolve disagreements involving any matter under Part B of the IDEA, including matters arising prior to the filing of a due process complaint. Mediation may be requested by parents or the public agency. If during an IEP or IFSP team meeting, a parent disagrees with a child's IEP or IFSP for the special education services provided to the child, the IEP or IFSP team shall provide the parent, in plain language, an oral and written explanation of the parent's rights to request mediation, contact information, including a telephone number that a parent may use to receive more information about the mediation process, and information regarding pro bono representation and other free or low-cost legal and related services available in the area. Parents may request the information about mediation to be translated into the parent's native language. If the native language spoken by the parents is spoken by more than 1% of the student population in the local school system, the IEP or IFSP team shall provide the parent with the translated document within 30 days after the date of the request. Meeting to encourage mediation. A public agency may offer to parents who elect not to use the mediation process to meet at a time and location convenient to the parents, to explain the benefits of the mediation process and encourage parents to use the process. Difference between a state complaint and a due process complaint. In addition to mediation, parents have the right to use the state complaint process or the due process complaint process to resolve disagreements with the public agency. These options have different rules and procedures. The IDEA regulations have separate procedures for state complaints and for due process complaints. As explained below, any individual or organization may file a state complaint alleging a violation of any IDEA requirement by a public agency. Only a parent or a public agency may file a due process complaint on any matter relating to the identification, evaluation, early intervention services, or educational placement of a child with a disability, or the provision of a free appropriate public education, FAPE, to the child. MSDE staff generally must resolve a state complaint within 60 calendar days unless the timeline is properly extended. An ALJ must hear a due process complaint, if not resolved through a resolution meeting or through mediation, and issue a written decision within 45 calendar days after the end of the resolution period or the adjusted resolution period, unless the ALJ grants a specific extension of the timeline at the parent's request or the public agency's request. For an overview and comparison of these options, see the attachment to this document. State complaint. An organization or individual, including one from another state, has the right to file a state complaint with the Maryland State Department of Education, MSDE. In order for the state to conduct an investigation, the written complaint must meet specific criteria as required in the IDEA regulations. The MSDE is responsible for disseminating widely the state complaint procedures to parents and other interested individuals, including parent training and information centers, protection and advocacy agencies, independent living centers, and other appropriate entities. If an organization or individual, including one from another state, believes a public agency has violated a federal or state law or regulation concerning an early intervention or special education requirement, or that a public agency has not implemented a due process hearing decision, a state complaint may be filed in order to resolve the matter. The complaint must be filed with the MSDE and should be addressed to the Assistant State Superintendent, Division of Early Intervention and Special Education Services, Maryland State Department of Education, 200 West Baltimore Street, Baltimore, Maryland, 21201. The person or organization that files a state complaint with MSDE must also send a copy of the complaint to the public agency at the same time. To assist with filing the complaint, detailed procedures and a form are available on the MSDE website at www.marylandpublicschools.org or by calling the Division's Complaint Investigation and Due Process Branch at 410-767-7770. The state complaint must include a statement that the public agency has violated a requirement of federal or state law or regulation, or that the public agency failed to implement a due process hearing decision, the facts upon which the statement is based, the signature and contact information for the person or organization filing the state complaint, and if the state complaint is alleging a violation with respect to a specific child, the name and address of residence of the child, the name of the school the child is attending, in the case of a homeless child or youth, available contact information for the child, and the name of the school the child is attending, a description of the nature of the problem of the child, including facts relating to the problem, and a proposed resolution of the problem to the extent known and available to the party at the time the state complaint is filed. Note: MSDE has model forms to assist parents and public agencies in filing a state complaint. Parents, public agencies, and other parties may use the model form, or they may use any other form as long as it meets the requirements above. A state complaint must allege a violation that has occurred not more than 1 year prior to the state receiving the complaint. MSDE must issue a written decision that contains findings of fact and conclusions within 60 calendar days of receipt of the state complaint, and may extend the 60-day timeline only if exceptional circumstances exist regarding a particular complaint, or the parent and the public agency involved voluntarily agree to extend the time to try mediation or alternative means of dispute resolution. At a minimum, MSDE shall conduct an independent on-site investigation if it is determined necessary, provide the complainant the opportunity to submit additional information, either orally or in writing, about the allegations in the state complaint, provide the public agency with the opportunity to submit a proposal to resolve the complaint, and provide the parties with the opportunity to voluntarily engage in mediation consistent with Title 34 of the Code of Federal Regulations, Part 300, Section 506. Review all relevant information and make an independent determination as to whether a public agency has violated requirements of federal and state laws, and issue a written decision to the complainant and the public agency that addresses each allegation in the complaint and contains findings of fact and conclusions and the reasons for MSDE's final decision. The decision will also include procedures for the effective implementation of the final decision, if needed, including technical assistance activities, negotiations, and corrective actions to achieve compliance. If MSDE determines a public agency has failed to provide appropriate services, the final written decision shall address how a public agency is to remediate the denial of those services appropriate to the needs of the child, including corrective action appropriate to address the needs of the child, such as compensatory services or monetary reimbursement, and appropriate future services for all children with disabilities. Resolving a state complaint. Mediation and other less formal methods to resolve the disagreement may be available and are encouraged. If the parties resolve the complaint, MSDE does not conduct an investigation under the federal regulations. Resolving a state complaint that is the subject of a due process hearing. If MSDE receives a state complaint that is also part of a due process hearing, or if a state complaint contains multiple issues of which one or more are part of a hearing, MSDE must set aside any part of the state complaint that is being addressed in the due process hearing until the conclusion of that due process hearing. However, any issue in the state complaint that is not part of the due process hearing must be resolved using the timeline and procedures described above. If an issue is raised in a state complaint that has previously been decided in a due process hearing involving the same parties, the hearing decision is binding, and MSDE shall inform the complainant to that effect. Due process complaint. The parent, early intervention services provider, local lead agency, or a public agency may file a due process complaint on any matter relating to the identification, evaluation, or placement of a child, or the provision of early intervention services or educational placement, or the provision of a free appropriate public education, FAPE, to a child. The due process complaint must allege a violation that occurred within 2 years of the date the parent or agency knew or should have known about the alleged actions that forms the basis of the due process complaint, or if the state has an explicit time limitation for requesting such a due process hearing under this part, in the time allowed by that state law. This timeline does not apply to a parent if the parent was prevented from filing a due process complaint within the timeline because the public agency specifically misrepresented that it had resolved the issues identified in the due process complaint, or the public agency withheld information from the parent that it was required to provide under IDEA. To file a due process complaint, the parent or the public agency, or the parent's attorney or the public agency's attorney, must submit a due process complaint to the other party and the OAH. The complaint must contain all of the content listed below and must be kept confidential. To assist parents in filing a due process complaint, a request for mediation and due process complaint form is available from the public agency from which the early intervention services are provided, where the child attends school, and on the MSDE website at www.marylandpublicschools.org. Information is also available about any potential free or low-cost legal resources at a parent's request, or if the parent or agency files a due process complaint. For further assistance, contact the public agency's Early Intervention Office, Special Education Office, or the MSDE Division of Early Intervention and Special Education Services at 410-767-7770. Content of the due process complaint. The due process complaint must include the name of the child, address of the child's residence, or, for a homeless child, available contact information, name of the school the child is attending, name of the public agency responsible for the education of the child, that is, the local school system, a description of the problem of the child relating to the proposed or refused initiation or change, including facts related to the problem, and a proposed resolution of the problem to the extent known and available to the party at the time of the complaint. The parent or the public agency may not have a due process hearing until the parent or the public agency, or the parent's attorney or the public agency's attorney, files a due process complaint that includes this information. MSDE has available model forms to assist parents and public agencies in filing a due process complaint. Parents, public agencies, and other parties may use the model form, or they may use any other form as long as it meets the requirements above. Response to the due process complaint. When a party files a due process complaint, the public agency responsible for the child's early intervention and education shall inform the parent of free or low-cost legal and other relevant services available, provide the parent with a copy of the procedural safeguards document, and inform the parent of the availability of mediation. If the public agency has not sent a prior written notice to the parents regarding the issues raised by the parent in the due process complaint, the public agency shall send the parent a response within 10 days of receiving the due process complaint, containing an explanation of why the public agency proposes or refuses to take the action or actions, a description of any other options that the public agency considered and the reasons why these options were rejected, a description of each evaluation procedure, assessment, record, or report which was used as the basis for the proposed or refused action, a description of other factors that were relevant and used as the basis for the proposed or refused action, a statement that the parents of a child with a disability have protections under the procedural safeguards of this part, and if this notice is not an initial referral for evaluation, the means by which a copy of the procedural safeguards can be obtained, and sources for parents to contact to obtain assistance in understanding the provisions of the IDEA. This response does not preclude the public agency from asserting that the parent's due process complaint was insufficient, where appropriate. Sufficiency of notice. The due process complaint is considered sufficient unless the party receiving the complaint notifies OAH and the other party in writing within 15 days of receiving it that the receiving party believes that the due process complaint does not meet the content requirements. Within 5 days of receiving notice of the deficiency, OAH will determine whether the due process complaint meets the content requirements and immediately notify the parties in writing. A party may amend its due process complaint only if the other party consents in writing and is given the opportunity to resolve the issues through a resolution meeting as noted below, or OAH grants permission not later than 5 days before a due process hearing occurs. The timeline for the resolution meeting and the due process hearing begins again with the filing of the amended due process complaint. Child status during proceedings. During the pendency of any administrative or judicial proceeding, except as provided under the discipline section, unless the parent and public agency agree otherwise, the child must remain in his or her current early intervention or educational placement. If the proceeding involves an initial application for early intervention services, the child must receive those services that are not in dispute. If the proceeding involves an initial application for initial admission to public school, the child, with parental consent, must be placed in the public program until the completion of all proceedings. If the decision of the ALJ agrees with the parents that a change of early intervention services or education placement is appropriate, that placement becomes the child's current placement during the pendency of subsequent appeals. However, if the complaint involves an application for initial services under this part from a child who is transitioning from Part C, IFSP, of the Act to Part B, IEP, and is no longer eligible for Part C services because the child has turned 3, the public agency is not required to provide the Part C services that the child had been receiving. If the child is found eligible for special education and related services under Part B, and the parent consents to the initial provision of special education and related services under Part 300, Section 300, Paragraph B, then the public agency must provide those special education and related services that are not in dispute between the parent and the public agency. Resolution process. Within 15 calendar days of receiving a parent's due process complaint, and before the due process hearing begins, the public agency must hold a meeting with the parent and the relevant member or members of the Individualized Family Service Plan, IFSP, team, or Individualized Education Program, IEP, team, who have specific knowledge of the facts identified in the parent's due process complaint. The meeting must include a representative of the public agency who has decision-making authority on behalf of the public agency, and may not include an attorney representing the public agency unless the parent brings an attorney. The parent and the public agency determine the relevant members of the IFSP or IEP team to attend the meeting. The purpose of the meeting is for the parents to discuss the due process complaint and the facts that form the basis of the complaint, so that the public agency has the opportunity to resolve the dispute. The resolution meeting is not necessary if the parent and the public agency agree in writing to waive the meeting, the parent and the public agency agree to try mediation, or the public agency initiated the due process complaint. If the public agency has not resolved the due process complaint to the parent's satisfaction within 30 calendar days of receiving the complaint, the resolution period, the due process hearing may occur. The 45-day timeline for issuing a final decision begins at the end of the 30-day resolution period, unless one of the following circumstances described below in the adjustments to the 30 calendar day resolution period or the expedited timeline sections applies. Adjustments to the 30-day resolution period. Except when the parent and the public agency have agreed to extend the resolution process, waive the resolution process, or to use mediation, a parent's failure to participate in the resolution meeting will delay the timelines for the resolution process and the due process hearing until the meeting is held. If, after making reasonable efforts and documenting such efforts, the public agency is not able to obtain the parent's participation in the resolution meeting, the public agency may, at the end of the 30-day resolution period, request that the ALJ dismiss the due process complaint. Documentation of the public agency's efforts must include a record of attempts to arrange a mutually agreed upon time and place, such as detailed records of telephone calls made or attempted and the results of those calls, copies of correspondence sent to the parents and any responses received, and detailed records of visits made to the parent's home or place of employment and the results of those visits. If the public agency does not hold the resolution meeting within 15 calendar days of receiving notice of a parent's due process complaint, or does not participate in the resolution meeting, the parent may request that the hearing commence and the decision be issued within 45 calendar days. If the parent and the public agency agree in writing to waive the resolution meeting, then the 45-day timeline for the due process hearing starts the next day. After the start of mediation or the resolution meeting, and before the end of the 30-day resolution period, if the parent and the public agency agree in writing that no agreement is possible, then the 45-day timeline for the due process hearing starts the next day. If the parent and the public agency agree to try mediation, and at the end of the 30-day resolution period, both parties can agree in writing to continue the mediation process until an agreement is reached. However, if either the parent or the public agency withdraws from the mediation process, then the 45-day timeline for the due process hearing starts the next day. Resolution Settlement Agreement. If a resolution to the dispute is reached at the resolution meeting, the parent and the public agency must enter into a written, legally binding agreement that is signed by the parent and a representative of the public agency that has the authority to hold the public agency to the agreement, and enforceable in any state court of competent jurisdiction, a state court that has authority to hear this type of case, or in a federal district court. If the parent and the public agency enter into an agreement as a result of the resolution meeting, either party may void the agreement within 3 business days. Due process hearing. The parent or the public agency involved in a dispute has the opportunity for an impartial due process hearing when filing a due process complaint. A parent or the public agency must request the hearing within 2 years of the date the parent or public agency knew about the alleged action that forms the basis of the due process complaint. The only exceptions to the 2-year requirement are 1. If a parent was prevented from filing a due process complaint due to specific misrepresentations by the LEA that it had resolved the problem forming the basis of the due process complaint, or 2, if a parent was prevented from filing a due process complaint due to the LEA's withholding of information that is required to be provided to a parent. An administrative law judge, ALJ, is an employee of the Office of Administrative Hearings and not of MSDE, does not have a personal or professional interest that conflicts with their objectivity in the hearing, is knowledgeable and understands the provisions of the IDEA and federal and state regulations pertaining to the IDEA and legal interpretations of the IDEA, and has the knowledge and ability to conduct hearings and to make and write decisions consistent with appropriate standard legal practice. A person who otherwise qualifies to conduct a hearing is not an employee of MSDE solely because he or she is paid by MSDE to serve as a hearing officer. MSDE will keep a list of persons who serve as hearing officers to include a statement of the qualifications of each of those persons. This information is available on the OAH website. Subject matter of a due process complaint. The party, the parent or the public agency, that files the due process complaint may not raise issues at the due process hearing that were not addressed in the due process complaint, unless the other party agrees. Hearing rights. Either party to a due process hearing, including a hearing on IDEA disciplinary procedures, has the right to represent yourself or be represented by an attorney at due process hearings in accordance with State Government Article Section 9-1607.1, Annotated Code of Maryland. Be accompanied and advised by a lawyer and persons with special knowledge or training with respect to the problems of children with disabilities. Present evidence and confront, cross-examine, and require the attendance of witnesses. Prohibit the introduction of any evidence at the hearing that has not been disclosed to that party at least 5 business days before the hearing. Obtain a written or, at the parent's option, electronic, word-for-word record of the hearing, and obtain written or, at the parent's option, electronic findings of fact and decisions. Additional disclosure of information. At least 5 business days before a due process hearing, the parent and the public agency must disclose to each other all evaluations completed by that date and recommendations based on those evaluations that the parent or the public agency intend to use at the hearing, An ALJ may prevent any party that does not comply with this requirement from introducing the relevant evaluation or recommendation at the hearing without the consent of the other party. Parents' rights. The parent has the right to have the child present, open the hearing to the public, and have the record of the hearing, the findings of fact, and decisions provided to you at no cost. Hearing decision. The ALJ decision on whether a child received a free appropriate public education, FAPE, must be based on substantive grounds. In matters alleging a procedural violation, an ALJ may find that the child did not receive FAPE only if the procedural inadequacies interfered with the child's right to a FAPE, significantly interfered with the parent's opportunity to participate in the decision-making process regarding the provision of a FAPE to the child, or caused a deprivation of an educational benefit. None of the provisions described above can be interpreted to prevent an ALJ from ordering a public agency to comply with the requirements in the procedural safeguards section of the federal regulations under Part B of the IDEA, Title 34 of the Code of Federal Regulations, Part 300, Section 500, through Part 300, Section 536. The ALJ decision on whether a child was appropriately identified, evaluated, or placed, or whether the child was appropriately provided early intervention services, must be based on substantive grounds. In matters alleging a procedural violation, an ALJ may find that the child was not appropriately identified, evaluated, placed, or provided early intervention services only if the procedural inadequacies impeded the child's right to identification, evaluation, and placement or provision of early intervention services for the child and that child's family, significantly impeded the parent's opportunity to participate in the decision-making process regarding identification, evaluation, placement, or provision of early intervention services for the child and that child's family, or caused a deprivation of an educational or developmental benefit. Separate due process complaint. Nothing in the procedural safeguards section of IDEA prevents a parent from filing a separate due process complaint on an issue separate from a due process complaint already filed. Timelines and convenience of a hearing. Not later than 45 calendar days after the end of the 30 calendar day period for resolution meetings, or as described under adjustments to the 30 calendar day resolution period, not later than 45 calendar days after the end of the adjusted time period, a final decision is reached in the hearing, and a copy of the decision is mailed to each of the parties. An ALJ may grant specific extensions of time beyond the 45-day time period at the request of either party. Each hearing must occur at a time and place that is reasonably convenient to the parent and the child. Expedited due process hearing, IEP only. A public agency is responsible for arranging an expedited due process hearing when a due process complaint is filed on behalf of a child with a disability regarding a child with a disability who is not currently enrolled and attending school, the placement of a child with a disability in an interim alternative education setting, or a manifestation determination. The due process hearing must occur within 20 school days of the date the complaint is filed. The ALJ must make a determination within 10 school days after the hearing. A resolution meeting must occur within 7 calendar days of receiving notice of the due process complaint, and the due process hearing may proceed unless the matter has been resolved to the satisfaction of both parties within 15 calendar days of receiving the due process complaint. Hearing decisions. After deleting any personally identifiable information, the public agency is responsible for transmitting the findings and decisions to the State Advisory Panel, and also must make those findings and decisions available to the public. Finality of hearing decision. An ALJ decision is final unless appealed by either the parents or the public agency. Any party aggrieved by the findings and decisions has the right to bring a civil action with respect to the complaint presented in the due process hearing. Appeal. Any party to the hearing who does not agree with the findings and decision has the right to appeal by bringing a civil action in any state court of competent jurisdiction or in any district court of the United States without regard to the amount of controversy, within 120 days of the date of the ALJ decision. In any civil action, the court will receive the records of the administrative proceedings, hear additional evidence at the parent's request or at the public agency's request, base its decision on the preponderance of the evidence, and grant the relief that the court determines to be appropriate. Nothing in Part B of the IDEA restricts or limits the rights, procedures, and remedies available under the U.S. Constitution, the Americans with Disabilities Act of 1990, Title V of the Rehabilitation Act of 1973, Section 504, or other federal laws protecting the rights of children with disabilities. Except that before the filing of a civil action under these laws seeking relief that is also available under Part B of IDEA, the due process procedures described above must be exhausted to the same extent as would be required had the parent or public agency filed the action under Part B of the IDEA. This means that parents may have remedies available under other laws that overlap with those available under the IDEA, but in general, to obtain relief under those other laws, parents must first use the available administrative remedies under the IDEA, that is, the due process complaint, resolution meeting, and impartial due process hearing procedures, before going directly into court. Attorney's fees, IEP and IFSP. In any action or proceeding brought under IDEA, the court in its discretion may award reasonable attorney's fees to the parents or guardians of a child with a disability who is the prevailing party, to a prevailing party who is MSDE, or any other public agency against the attorney of the parent who files a complaint or subsequent cause of action that is frivolous, unreasonable, or without foundation, or against the attorney of the parent who continued to litigate after the litigation clearly became frivolous, unreasonable, or without foundation, or to a prevailing party who is MSDE, or any other public agency against the attorney of the parent, or against the parent, if the parent's complaint or subsequent cause of action was presented for any improper purpose, such as to harass, to cause unnecessary delay, or to needlessly increase the cost of litigation. Fees awarded must be based on rates prevailing in the community in which the action arose, for the kind and quality of services furnished. No bonus or multiplier may be used in calculating the fees awarded. Funds available under the IDEA shall not be used to support legal fees, court costs, or other costs associated with a cause of action brought on behalf of a child with a disability to ensure FAPE. Fees may not be awarded under the following circumstances. For any IFSP or IEP team meeting, unless it is convened as a result of a due process hearing or judicial action. For mediation conducted prior to filing a due process complaint. For resolution meetings. And for services following a written settlement offer to the parent if the offer is made within the timelines under Rule 68, Federal Rules of Civil Procedure, or in an administrative proceeding more than 10 days before the proceeding begins. The offer is not accepted within 10 days, and the court finds the relief obtained by the parent in the hearing is not more favorable to the parent than the offer of settlement. Fees and costs may be awarded if the parent was substantially justified in rejecting the settlement offer. Fees may be reduced under the following circumstances. The parent or the parent's attorney unreasonably prolonged resolving the dispute. The amount of fees unreasonably exceeds the hourly rate prevailing in the community for similar services by attorneys of reasonably comparable skill, reputation, and experience. The time and services were excessive considering the nature of the proceeding, or the attorney did not provide the appropriate information in filing the due process hearing request notice. Fees will not be reduced if the public agency prolonged the resolution or there was a violation of the procedural safeguard requirements. Because the parent's right to recover attorney's fees depends upon meeting certain conditions set out in the IDEA, parents should discuss this matter with their attorneys. Attachment: IDEA Dispute Resolution Processes Comparison Chart. Mediation: who can initiate the process? Parents or public agency, but must be voluntary for both. What is the time limit for filing? None specified. What issues can be resolved? Any matter under Part 300, including matters arising prior to the filing of a due process complaint. There are exceptions. The following is footnote 2. Such exceptions include: the public agency may not file a due process complaint or use mediation to override a parent's refusal to consent to the initial provision of special education services. The public agency may not file a due process complaint or use mediation to override a parent's refusal to consent to an initial evaluation or reevaluation of a parentally placed private school child or homeschooled child. The right of parents of parentally placed private school children to file a due process complaint is limited to the public agency's failure to meet the child find requirements. The public agency's failure to provide a highly qualified teacher is not an issue subject to due process, but a state complaint could be filed with the State Education Agency, SEA. Now back to the attachment. What is the timeline for resolving the issues? None specified. Who resolves the issues? Parent and public agency with a mediator. The process is voluntary, and both parties must agree to any resolution. Due process complaint. Who can initiate the process? Parent or public agency. What is the time limit for filing? 2 years of when the party knew or should have known of the problem with limited expectations. The following is footnote 1. The time limit does not apply to a parent if the parent was prevented from filing a due process complaint due to 1. Specific misrepresentations by the public agency that it had resolved the problem forming the basis of the due process complaint, or 2. The public agency's withholding of information from the parent that was required under Part 300 of IDEA to be provided to the parent. Now back to the attachment. What issues can be resolved? Any matter relating to the identification, evaluation, or educational placement or provision of a free, appropriate public education. There are exceptions. What is the timeline for resolving the issues? 45 days from the end of the resolution period, unless a specific extension to the timeline is granted. The following is footnote 3. If the due process complaint is filed for an expedited hearing pursuant to discipline procedures, or the child is not currently enrolled and attending school, the resolution period is 15 calendar days, with the meeting being held within 7 days. If the matter has not been resolved to the satisfaction of both parties, the hearing must occur within 20 school days of the date the hearing is requested, and a decision must be issued within 10 school days after the hearing. The following is footnote 4. A hearing officer or ALJ may grant specific extension of time at the request of either party. Now back to the attachment. Who resolves the issues? Hearing officer or administrative law judge, ALJ. Resolution process. Who can initiate the process? Public agency schedules the resolution meeting upon receipt of a due process complaint unless the parties agree to waive or use mediation. What is the time limit for filing? Triggered by a parent's due process complaint. What issues can be resolved? Same as the issues raised in the parent's due process complaint. What is the timeline for resolving the issues? Public agency must convene a resolution meeting within 15 days of receipt of the parent's due process complaint, unless the parties agree in writing to waive the meeting or agree to use mediation. Resolution period is 30 days from receipt of the parent's due process complaint, unless the parties agree otherwise, and the parent or public agency fails to participate in the resolution meeting, or the public agency fails to convene the resolution meeting within 15 days of receipt of the parent's due process complaint. The following is footnote 3. If the due process complaint is filed for an expedited hearing pursuant to discipline procedures, or the child is not currently enrolled and attending school, the resolution period is 15 calendar days, with the meeting being held within 7 days. If the matter has not been resolved to the satisfaction of both parties, the hearing must occur within 20 school days of the date the hearing is requested, and a decision must be issued within 10 school days after the hearing. The following is footnote 5. The regulations allow for adjustments to the 30-day resolution period. The 45-day timeline for the due process hearing starts the day after one of the following events. 1. Both parties agree in writing to waive the resolution meeting. 2. After either the mediation or resolution meeting starts, but before the end of the 30-day period, the parties agree in writing that no agreement is possible. 3. If both parties agree in writing to continue the mediation at the end of the 30-day resolution period, but later the parent or public agency withdraws from the mediation process. The following is footnote 6. Parent failure to participate in the resolution meeting delays the timelines for the resolution process and the due process hearing until the meeting is held. The following is footnote 7. If the public agency fails to hold the resolution meeting within 15 days of receiving the parent's due process complaint, or fails to participate in the resolution meeting, the parent may seek the intervention of an ALJ to begin the due process hearing timeline. Now back to the attachment. Who resolves the issues? Parent and public agency. Both parties must agree to any resolution. State complaint. Who can initiate the process? Any individual or organization, including those from out of state. What is the time limit for filing? 1 year from the date of the alleged violation. What issues can be resolved? Alleged violations of Part B of IDEA or Part 300. What is the timeline for resolving the issues? 60 days from receipt of the complaint, unless an extension is permitted. The following is footnote 8. The timeline for resolving the state complaint may be extended if exceptional circumstances exist with respect to a particular complaint or the parent, or individual or organization, if mediation or other alternative means of dispute resolution is available to the individual or organization under state procedures, and the public agency agree to extend the time to engage in mediation or to engage in other alternative means of dispute resolution, if available in the state. Now back to the attachment. Who resolves the issues? Maryland State Department of Education. The following is footnote 9. The MSDE complaint procedures provides the public agency with the opportunity to respond to the complaint, including, at the discretion of the public agency, a proposal to resolve the complaint, and an opportunity for the parent who files a complaint and the public agency to voluntarily engage in mediation. In some cases, the complainant and public agency may be able to resolve the dispute without the need for MSDE to resolve the matter. Maryland State Department of Education, Division of Early Intervention and Special Education Services, 200 West Baltimore Street, Baltimore, Maryland, 21201, 410-767-0249, phone, 410-333-1571, fax, marylandpublicschools.org. Copyright 2021, Maryland State Department of Education, Division of Early Intervention and Special Education Services. Produced under the guidance of Marcella E. Frankowski, Assistant State Superintendent, Division of Early Intervention and Special Education Services. Please include reference to the Maryland State Department of Education, Division of Early Intervention and Special Education Services on any replication of this information. To request permission for any use that is not fair use, as that term is understood in copyright law, contact Maryland State Department of Education, Division of Early Intervention and Special Education Services, 200 West Baltimore Street, 9th floor, Baltimore, Maryland, 21201, phone 410-767-0249, marylandpublicschools.org. This document was developed using grant funding provided to the Maryland State Department of Education from the U.S. Department of Education, Office of Special Education and Rehabilitative Services, OSERS, Office of Special Education Programs, OSEP, under the Individuals with Disabilities Education Act. The Maryland State Department of Education does not discriminate on the basis of race, color, sex, age, national origin, religion, or disability in matters affecting employment or in providing access to programs. For inquiries related to departmental policy, please contact the Equity Assurance and Compliance Branch, phone 410-767-0433, TTY 410-767-0426, fax 410-767-0431.